An employer may fire an employee for any reason except an unlawful reason.
What did working in HR actually teach you about the way employers think that you couldn't learn in law school? A lot of people think HR is, on their side as an employee.
Well, many human resources professionals they want to do the right thing. They're good people. They're trying to get along within the company and navigate employment for themselves. So for the most part, I do know that many HR professionals are trying to do the right thing, but whether they carry out the law in a manner that's not only fair but lawful is a different story.
So I just got fired. I have no idea if it was legal. What's the first thing I should do?
The first thing you should do is call an attorney who practices employment law. I mean, there are many attorneys out there. In Texas, attorneys can practice any type of law that we like as long as we do a good job. But an employment attorney is aware of an employee's legal rights, the status of the law that's always changing. So consulting with an attorney that practices employment law can give you a sense of what's actionable, what's not, and provide some next steps on best possible outcomes.
So everyone says that Texas is an at-will state, and my employer can fire me for anything. Is that actually true?
For the most part, yes, it is true. An employer may fire an employee for any reason except an unlawful reason. So
Unless they can't.
think the discrimination, age, race, religion, disability, medical leave, gender. An employer may not dismiss an employee for one of those reasons, or if they've participated in some sort of protected activity, that might be an unlawful reason to dismiss an employee.
Okay, so how long do I have before I lose my right to do something about what just happened to me? Is there a window of time?
There is a window of time for employees. I usually recommend that employees take action within at least 6 months, 180 days. There are state laws that mirror federal laws, and all of those have different timelines. Federal law is 300 days, state law at least 180 days. But for some other protections like whistleblower activity, there are very short timelines, 60 days, 90 days, that have very tight filing requirements. So as soon as an employee thinks that they're in some sort of questionable situation, they really should get some legal advice quickly.
So, a lot of times, an employee gets into a situation and they think, they know something is wrong, but they're scared to even seek legal advice because I'm sure you see this, where they're afraid to even talk to a lawyer because they think somehow this is going to go back to their employer, and then they're going to lose their job and it's going to be the worst day of their life. So how do you address that fear?
Well, it is very scary speaking up, as soon as I mean, employees feel like as soon as they say something, now they have a target on their back. If they seek advice with an attorney, those conversations are always protected by the attorney-client privilege. So there's no way that that can get back to the employer. And, a large part of our practice, we speak with employees who are in that very situation. They're worried about their jobs, they're worried about next steps. And speaking with an attorney can kind of, well, advise them of their legal rights and provide some advice on best steps to take while they're still on the job.